Hi, my name's Simon from writtenlegalenglish.com and welcome to this video. This video is the first in a series of videos where I want to present to you what I think are the most important articles and writings about why you should use plain legal English instead of old-fashioned legal writing or what we know as legalese. And the reason why these articles are so important, or why I think these are so important, is that they're not just anecdotal pieces of evidence, which although they are important, these are scientific empirical pieces of research which show that legal professionals actually prefer, although they might not know why, they actually prefer plain legal English over what we think legal English should be. In other words, we should think it should be this convoluted, legalese, difficult to understand style of English. So if we can begin to understand that legal professionals actually prefer plain English, then that will help us change our view about how we should write in legal English, or indeed legal language, in any language when you're trying to communicate to a client or to someone else their possibilities in the world of law. So this first study I want to concentrate on is a hugely important study. It's Legalese versus Plain English, an empirical study of persuasion and credibility in appellate brief writing by Benson and Kessler. This was published in 1987, but the research was actually done in 1985. The reason why this is so important is because this study is from 1985. Today, in 2019, we've got a much better awareness, a much better general awareness, and certainly practice around the world in legal jurisdictions, under statutory provisions, and in private practice as well, that clear legal English is better than legalese. So back then in 1985, when this study actually showed that legal professionals preferred plain English over legalese, back then when there wasn't this knowledge, this is what makes it so significant. So let's get into the nuts and bolts. And let me quote directly from the article what this article is all about. This article reports the first empirical research on the effectiveness of different prose styles in appellate briefs. Appellate judges and their research attorneys were asked to assess passages from briefs written in traditional legal prose or legalese. Other judges and research attorneys in the same court were asked to assess the same passages rewritten in plain English. By statistically significant margins, the respondents rated the passages in legalese to be substantively weaker and less persuasive than the plain English versions. Think about that for a second. It's substantively weaker, so the legal points which are discussed are actually weaker, or appeared to be weaker, purely because they were written in legalese, and that the plain English versions were seen to be legally more significant in terms of communicating the argument. Think about that for a second. Plain legal English communicated the points of law and the arguments in a clearer way, and that the legalese was less persuasive than the plain English version. Now, people who have been helping teach and talk about plain English for much longer than I have, for example, Brian Garner, has said that lawyers' writing is all about persuasion. Persuading the client, persuading the court, persuading opposing counsel that you are correct. So legal writing is about persuasion. So the skills of how you persuade someone is directly relevant to the way that you write, and this article shows, or the findings of this article show, that if you write in a plain English style, your writing will be more persuasive. Think about the time once more. This was 1985, when there was a lot of people who weren't happy with legal writing, but they didn't know the reasons why they weren't happy. They didn't know the reasons why they were unconvinced, or they found this legalese difficult to work with. And yet the beginning work was being done to explain why plain English is better than legalese. I'll take you to a passage in the conclusion where it says, lawyers who write in legalese are likely to have their work judged as unpersuasive and substantively weak, repeating what was said. Perhaps even more worrisome for these lawyers personally is the finding that their own professional credentials may be judged less credible. Just think about what that's saying. That's saying if you're writing in legalese, other lawyers, other legal professionals might think that you are actually less professional than you otherwise are, purely because of the type of language you're using to communicate in. Now that's quite something, isn't it? When in comparison to plain English. So the plain English version was seen as more meritocratically acceptable than writing in legalese. Well, that goes against the face of many criticisms of plain English. Many people think that plain English is too simple, it's not businesslike, it's not legal language. But yet here was a study in 1985 that said the opposite, that legalese actually made your writing in many legal aspects suffer, and plain English was better in many other respects. And that's why this article, when you go through it, and of course there's a link to the article below, is so significant and so important. And the other reason why this article is so significant and so important is because it actually talks you through how they changed legalese writing into plain English and critiqued the legalese writing, explaining what the problems are. And you can see just over my shoulder an example of this, where this is one of the original legalese appellate briefs, and they break it down explaining what's wrong and what the issues are. And I'll leave you to go through this in your own time. And there's another example for the other legalese passage which they deconstruct and rewrite in plain English. But also in the article is this wonderful anecdote from a sitting trial judge who said, "I read briefs prepared by very prominent law firms. I bang my head against the wall. I dash my face with cold water. I pass, I excerpt, I diagram, and still the message does not come through. In addition, the structural content is most often mystifying." So here is a judge who receives legal writing in various different forms from professional law firms and this trial judge evidently has had much difficulty in actually trying to understand what is it that this law firm, that this lawyer is trying to communicate. All the time asking the question to himself or herself, what is the lawyer trying to say? And on top of that, why couldn't the lawyer say this in an easier way? And this study shows us that this easier way is much better than legalese across a number of different areas, from being more persuasive, for appearing more meritocratic, and at a higher level of legal writing, in particular as regards arguing the substantive points of law. As I said, the link to the article is in the video description below this video. If you're watching on YouTube, if you're watching on Facebook, I think it will be above the video. And if you're watching on my website, then you'll see the link next to the video. So download the article, take your time to read through it. It's not very long. I think it's only around about 22 pages of A4 with plenty of footnotes. So it's actually the content of the article is much, much shorter. But those footnotes are really, really important, because that's where I started on my journey of understanding what plain English is, using plain English, and trying to teach others about the benefits of plain English. Because in those footnotes, if you analyse them and you find those articles which are being referred to, that's where you'll start to understand the amount of work being done to explain why plain legal English is much better than legalese across a number of different areas. I'll leave it there for today. I'll be back again soon with another video going through another article and explaining why that article should be on your reading list to develop yourself as a lawyer and communicate in plain English. So I'll see you again soon.